They thought they erased me with a signature. They planned to toast the sale, wire themselves the cash, and leave me with memories. 2 months later, in a courtroom with bad lighting and a clock that ticked too loud, the judge told them to transfer me the money immediately, and that wasn't even the part that stunned them most. If you clicked on this because you saw, after her lies, she took $330,000, the judge made her give it back, you're in the right place. I'm the woman behind this channel. And today, I'm laying out exactly how a will reading went sideways, how I was publicly cut out of my father's estate, and how I turned it without a screaming match, without a miracle, and without breaking the law. What I used wasn't a secret weapon so much as a quiet one, a piece of paper everyone in the room assumed was meaningless until it wasn't. I run a channel called After Her Lies. I'm 36. I live in a one-bedroom near Irving Park in Chicago, and until March 3rd, 2025, my father owned a small HVAC company called Blake Heating Air, the kind of shop that still picks up the phone on Sundays in January when furnaces die. He married Diane 5 years after my mother died. My stepbrother Tyler is 28 and loud about his crypto wins and quiet about everything else. We were never close, but we were civil at holidays. When my dad got sick last summer and then worse around Thanksgiving, Diane moved everything into we language. We'll handle it. We've decided. We're working with a new attorney, and my calls started going unanswered. He passed on March 3rd, 2025. I found out from a text. The numbers hit like cold water. 3325. I drove straight to the house on North Hoyne, the 2-flat he bought in 1998, where I grew up above the shop's first office. Diane opened the door like I'd come to sell her cable. There's going to be a will reading, she said, her tone careful, like a script. At a trust office. Thursday the 13th at 10. She was precise with dates now. She also mentioned the updated will and codicil twice, like she wanted to make sure I heard both. At the trust office on March 13th, the receptionist offered bottled water with the label peeled off. The man who handled the estate, a partner named Michaels, kept his chin tipped up like he was measuring me for a lie. The stakes were laid out quickly. The estate would include the business, the house, a 2019 Ford Transit, a small life insurance check, and a brokerage account that had, according to the statement on the table, $330,000 as of January 31st, 2025. There were official envelopes, blue tabs, and the heavy smell of toner. A notary sat in the corner, bored. Michaels read the will dated August 20th, 2024. It left the residue to Diane, appointed her as personal representative, and contained a no-contest clause that said if any heir challenged the will, they forfeited any gift they would otherwise receive. The codicil, dated February 23, 2025, 8 days before my father died, revoked a specific bequest to me. It said he had already provided for me. It was 2 paragraphs that deleted me without a word to my face. When Michaels finished, Diane looked at me with what she probably practiced in a mirror. Regret and firmness. Tyler smirked at his phone. The humiliation wasn't subtle. I don't cry easily. I also don't perform rage on command. I asked for copies. I asked to see the notary stamp. I asked to see the durable power of attorney they had mentioned during illness. Michael said the DPOA was not part of probate. He said the codicil was clear. He said, Aaron, if you contest this, you'll trigger the no contest clause. He said it like a parent warning a child not to touch the stove. What was at stake was not abstract. It was a house with a mortgage balance of about $162,000. It was a business that grossed $1.2 million last year and netted after expenses around $180,000. It was a brokerage account with $330,000. It was the right to decide what happened to the company my father built from 2 vans and a wrench he bought with a credit card in 1993. It was also the right to walk out of that office not erased. I left with a folder and a headache. That night, I sat on my floor and made a list. I didn't have to outgun them. I had to outlast them. I had my father's voice note from January 15th, 2025. He asked me to help him upload a PDF to his bank from his phone. I hit record because he explained his passwords out loud. In the voice note, he said, "I kept the house transfer on death for you, and the TD Ameritrade account too. Diane will be okay. I set her up. This way is clean." He coughed. He repeated, "It's clean. Illinois is a one-party consent state. I knew that. I checked again anyway. I called my father's banker at Lakeshore Community Bank the next morning. I said, I'm not asking for distributions. I'm asking for beneficiary designations." He said he couldn't without letters of office from probate or a death certificate. I had the death certificate. I still needed letters. He paused and then said, "If there is a transfer on death designation, that's non-probate." I asked if the bank uses transfer on death registrations for brokerage. He said yes, if it's a TOD account. Some are, some aren't. He said, "I can't confirm over the phone." He also said he was in the office until 3 p.m. I went in person with the death certificate. He scanned my ID and walked to the back. When he came back, he didn't slide paper across the table. He said carefully, "There is a beneficiary designation on the brokerage, but there's a later instruction to remove it, dated February 24th. Solved the day after the Codicil. He said that instruction was signed by Diane under a durable power of attorney. I asked him to read me the exact words of the power of attorney. He said he couldn't. I asked if the DPOA was springing or immediate. He didn't answer, which was answer enough. I called 3 attorneys and hired the one who didn't talk down to me. Her retainer was $1,500. She said, "We are not going to contest the will first. We're going to challenge the use of the DPOA to change a non-probate asset and enforce non-probate transfers." She asked for the voice note. She asked for dates, every date I had. She asked if I had any other leverage. I said carefully that my dad had given me a share certificate for Blake Heating Air in 2019, after a winter when I ran dispatch for him while he was in the hospital with pneumonia. He'd issued me 25 out of 100 shares and signed a buy-sell agreement that required unanimous consent for any sale of the company's assets, with a right of first refusal for any transfer. We both looked at each other over that number. She said, "That's leverage." I also pulled the recorder's website for Cook County and searched my father's name. On page 3, I found something from October 12, 2021, a transfer on death instrument toady for the house on North Hoyne. It named me as the beneficiary of the property. It had a notary seal and a recorder's stamp. It required revocation to be recorded. The site showed no revocation. I paid $14 for a certified copy. I printed 2. I stared at the line that made people assume these documents are ceremonial. This instrument transfers the described residential real estate to the designated grantee beneficiary on the owner's death. It was a sentence that turns grief into administration. It also does not go through probate. That would have been enough, probably. But I didn't want probably. I wanted the kind of leverage that isn't subject to someone else's interpretation. So I asked Michaels's office in writing for the notary journal page for the February 23rd Codicil. In Illinois, notaries are supposed to keep a record. It isn't always tidy. UPS stores keep them religiously. Private notaries sometimes don't. Michaels's assistant wrote back, "We do not release internal notary logs." My attorney issued a subpoena for it once the estate opened in probate court. We also filed a petition to enforce the toady and enjoin any sale of the house pending the court's determination. And we filed a motion to compel the bank to produce the DPOA and the paperwork used to remove the TOD beneficiary the day after the codicil. At the same time, Diane called me. She said, "If you stop, we'll give you $20,000 and you can keep your mother's ring." She made it sound generous. I said no. She said, "You're on YouTube, Aaron. You like attention." I said, "I like receipts." I hung up and backed up everything. My father kept paper in odd places. I found a copy of the 2019 buy-sell agreement in the bottom drawer of his old desk at the shop on Elston. The shop manager, Miguel, hugged me in the parking lot. He said, "There's talk they're going to sell to Fairview Mechanical for $600,000. He said he only heard pieces, that Tyler bragged, "We're cashing out." I read the buy-sell again, slower. It had a clause that said, no sale of substantially all assets without unanimous shareholder approval and without satisfying a right of first refusal to any existing shareholder on the same terms. I put my finger on that line and exhaled. We went to the emergency hearing about the house on April 8th. The judge didn't say much at first. He read the toady, checked the recording information, and asked Diane's counsel if there was any recorded revocation. There wasn't. He granted the injunction, no sale, no transfer, no listing until the court determined whether the toady controlled. He asked for briefing on whether a transfer on death instrument recorded in 2021 could be revoked by a codicil in 2025, not recorded with the recorder of deeds. He set it for May 2nd. Diane's counsel glared at me like I had stolen something. Then the bank produced the durable power of attorney. It was dated May 5th, 2023. It named Diane as agent. It was immediate, not springing. But it had a clause almost nobody pays attention to. Agent shall not make, change, or revoke beneficiary designations on any account unless expressly authorized herein. The paragraph that followed was blank. There was no express authorization. The banker's affidavit said Diane used that DPOA on February 24th to remove the TOD beneficiary designation. That was a problem for her, not for me. My attorney said, "Good." The word landed like a small metal object on a table. The notary journal for the codicil arrived through the court. It had an entry for February 23rd with my father's name. It listed a driver's license number and a signature that looked like my father's cut in half. There was a detail I couldn't get past. It showed the location as Michael's office downtown, but my father was at Northwestern Memorial that entire weekend, on morphine and oxygen, where I had visited him Saturday night around 8 p.m. and where the nurse had to lift his hand to sign a consent form. The hospital's logs, which my attorney subpoenaed, showed he didn't leave. The codicil could have been signed at the hospital. People do that. But the journal said it wasn't. It smelled like negligence at best. We ended up in 3 lanes at once, enforcing the toady for the house, fighting the improper use of the DPOA on the brokerage, and blocking any sale of the business with my shareholder rights. Each lane had a different speed limit and a different risk. If I challenged the will head-on, the no contest clause could be triggered and I'd risk everything, including my position as a residuary beneficiary if any asset fell back into the estate. But I wasn't doing that. I wasn't contesting the will. I was enforcing non-probate transfers and contractual rights. I could see the path, narrow but clean. Diane escalated in the way people do when they're certain they're right. She sent a letter through Michael's telling me I had 30 days to vacate the office if I still kept my father's desk there, as if I were squatting. She sent a cease and desist accusing me of interference with expectancy. She hired a PR friend to leave comments under my videos calling me a gold digger. I turned off comments for a week to keep my anger from performing itself. At the company, Tyler told the crew they'd each get a bonus when the sale went through. Miguel texted me, "We're with you." So he meant the kind of with you that counts when trucks need keys and customers need service on a 15-degree morning. At the end of April, Diane and Tyler called a shareholders meeting in the back of the shop to approve an asset sale to Fairview Mechanical, scheduled for May 10th. I showed up with my share certificate and the buy-sell agreement and sat in the folding chair they didn't offer me. Diane tried to speak for shareholders. I said, "How many shares do you own?" She paused. She said she was spouse and executor. I said, "How many shares?" Tyler said Dad had promised him all the business stuff. I placed my certificate on the table. I asked to see the corporate ledger. They didn't have it. I said, "No sale without unanimous approval, and you have neither my approval nor the right to force me to sell, and I have a right of first refusal on the same terms." Tyler shouted something about me being a YouTube lawyer. I kept my voice even. I said, "If you go forward, I'll seek an injunction and damages." They stormed out. Miguel winked at me like someone who just watched a door stay shut. By then, the bank's compliance department had done its own review. They produced an internal memo that said, "Agent used DPOA to remove TOD beneficiary without express authority." They reinstated the beneficiary designation to what it had been as of January 31st, subject to court confirmation. I didn't celebrate. People change their minds. Institutions wobble when pushed. I asked the banker for the exact form of the original TOD designation. He sent it. It named me. My attorney filed it with the court as an exhibit, along with the DPOA clause authorizing no change unless expressly authorized. We drafted a simple order: declare the change invalid, enforce the original TOD, compel transfer of the $330,000 to me upon completion of bank procedures. And then I saw the clause nobody expected. It was in the buy-sell agreement, paragraph 12C, a small line about fees and remedies. A shareholder who seeks to sell substantially all assets without required approval shall be responsible for the reasonable attorney's fees of the non-consenting shareholder. I read it twice, then a third time. It meant if they pushed the sale and I had to enjoin it, they would owe my fees. It was a sword and a shield in one sentence. When May 2nd arrived for the TOD hearing, the judge had done his homework. He asked 2 questions. Was the TOD properly recorded with the county recorder on October 12, 2021? Yes. Was any revocation recorded prior to the decedent's death on March 3, 2025? No. He cited the Illinois Residential Real Property Transfer on Death Instrument Act and said, on the record, a valid recorded TOD transfers the property at death outside probate. A will cannot revoke a recorded TOD unless the revocation is itself recorded. He signed the order confirming that the house passed to me on my father's death and directing the issuance of a certificate of transfer. Diane's counsel argued about fairness. The law isn't about feelings. We left with an order that was both ordinary and everything. At the next hearing on May 21st, we addressed the brokerage. Diane's attorney said she had acted within the scope of her authority as agent to remove the TOD beneficiary. The bank's affidavit said otherwise. The DPOA said otherwise. The judge read the clause into the record. No authority to make or change beneficiary designations unless expressly authorized. He found the removal invalid. He ordered the bank to honor the original TOD beneficiary designation and transfer the $330,000 to me within 10 days of receipt of the order and completion of standard procedures. He also reserved on my request for fees, telling us to brief it. Outside in the hallway, Diane told me I was tearing the family apart. I didn't raise my voice. I said, "You lied about what Dad wanted. I didn't tear anything." She shook her head like a parent with a stubborn toddler. Back at the shop, the Fairview deal stalled when their counsel asked for signed board minutes approving the sale. There were no minutes. Fairview didn't want to buy a lawsuit. I sent a clean, formal letter invoking my right of first refusal on any deal at the offered price and terms. If they were offering $600,000 cash at closing, I had a right to match it. They couldn't imagine I would. I didn't have to. The point wasn't to buy the company. The point was to block a forced sale and bring them to a buyout of my shares on neutral terms. The buy-sell had a valuation method. 3 times trailing 12 months net income, less debt, plus cash, with discounts only for lack of marketability if both parties agreed. We did the math. $180,000 for my 25, give or take adjustments. They escalated again. Michael sent a settlement offer, $50,000 if I waived everything and signed a non-disparagement clause. I didn't respond. He upped it to $80,000. I still didn't respond. My attorney drafted a petition to surcharge the executor Diane for fees paid from the estate toward transactions later found invalid, and for any distributions made that violated fiduciary duties, including her attempt to remove the TOD beneficiary. It wasn't vengeance. It was realism. Executors don't get to make up rules and pay themselves with the estate's checkbook. We prepared for a hearing on June 5th to confirm the bank transfer and address my fee request. The hallway outside the courtroom was crowded with people with manila folders and bad coffee. Diane wore a cream suit like armor. Tyler paced. The judge took the bench at 9:30. My attorney spoke in short, precise sentences. Diane's counsel tried to turn it into a fight about me not needing the money, about my channel, about my motives. The judge cut him off. Counsel, we are here on the application of law to facts. Then came the part where leverage, quiet and built over weeks, turns into gravity. We handed up the bank's memo acknowledging the improper use of the DPOA language itself, the original TOD beneficiary designation, the prior order on the house, and an affidavit from Fairview's counsel acknowledging they had paused the deal due to lack of proper corporate approvals. We attached the buy-sell agreement with the clause about unanimous consent. We attached the clause about fee shifting. We asked for 3 things. A final order directing the $330,000 transfer. An order restraining any sale of the business, absent unanimous shareholder approval or satisfaction of my right of first refusal, and a surcharge against the executor for the bank's legal fees caused by her improper instruction. The judge granted the first 2 without much ceremony. On the surcharge, he said he would defer and encouraged us to discuss fees at a settlement conference with a mediator. It was a nudge more than an order. We took it. In the elevator, Tyler muttered about me, making this about money. I said, this is about paper and promises. Money is what paper moves. The doors opened to the lobby that smells like floor cleaner and old air. I went home and made tea. Later that week, Michaels called my attorney with a different tone. They would agree to a structured buyout for my 25 of the company at $180,000, payable over 24 months at 6 interest, secured by a lien on the company's assets. They would agree not to sell without unanimous approval, and if they sought to sell later, they would provide me the right of first refusal with full terms. They would drop their demand for a non-disparagement clause. On the estate side, they would agree not to challenge the toady and to sign whatever the recorder needed. On fees, they would agree to pay the bank's legal costs out of Diane's personal funds, not the estate, without admitting fault. It was not an apology. It was movement. I said yes in principle and asked for the numbers in writing. When they arrived, the amortization schedule looked like a mortgage table. I flipped through each page with a pen. It was boring, which is what safety looks like in finance. We made a few edits. We insisted on a default clause that would accelerate the balance if they missed 2 payments. We insisted on personal guarantees. They pushed back. We compromised. 1 missed payment could be cured within 15 days. 2 missed payments within any 12-month period would accelerate. Personal guarantees stayed. Right then I thought about uploading a celebratory video. I didn't. The channel isn't a diary, it's a ledger. I posted the facts after we recorded the order on the brokerage transfer. I didn't call anyone a thief. I didn't write a monologue. I showed a stack of papers, the order date June 5th, 2025, the numbers, the basic explanation that non-probate transfers are not undone by wills, that a power of attorney is not a magic wand, and that shareholder rights exist on Tuesdays as well as on TV. I blurred names. I told everyone I would explain the buy-sell agreement in another video. I turned off comments again for a day because I needed silence more than strangers' opinions. When the $330,000 hit my account, the bank processed it in 2 steps. It arrived as a journal entry, then settled overnight. I didn't buy anything. I moved $250,000 to a high-yield savings account and $80,000 to a short-term treasury ladder. I kept 0 in checking from it because I didn't want to blur needs and wants. I called the tenant upstairs at the house and told her nothing would change right now. Her lease ran through January 31st, 2026 at $2,100 a month. Stability is a financial plan. We went to mediation about fees at the end of June. The mediator was efficient. He told us sincerely that nobody ever leaves completely happy. Diane said she acted in good faith. The bank's records disagreed. We settled on $9,400 for the bank's fees, paid by Diane personally. We didn't agree on my attorney's fees regarding the attempted sale. But we had the buy-sell fee clause. We reserved the right to seek them if they tried again. The mediator shrugged the way mediators do when they've done all they can. People ask me how I kept my voice even when they tried to humiliate me at the will reading. The answer is practice. Calm is a skill. Determination is a habit. Empathy is a choice that doesn't require surrender. I thought about how my father, flawed and stubborn, had tried to make the path clean by using tools the law offered. A transfer on death instrument for the house, a TOD designation for the brokerage, a buy-sell agreement so nobody could gut the company he built to pay for someone else's vacation. He didn't anticipate the codicil. Maybe he thought he would have time to explain it. Maybe he thought, I'll talk to Aaron next week. He ran out of next week's. In July, we signed the buyout. Payment started August 1st, 2025, $7,120, $13 a month for 24 months. I posted exactly one sentence about it. I used a paragraph to get to a payment schedule. The crew at Blake Heating Air stayed. They asked me to come by for lunch. I brought Portillo's. Miguel told me the phones were steady. He told me Tyler had started showing up earlier. Maybe that will stick. Maybe it won't. There were consequences beyond money. Diane lost her executor fee for extraordinary services. The court denied her request for it after the surcharge discussions. She kept the residue of the estate, as the will said, minus what never belonged to it because of the TODI and the TOD, minus the bank's fees she paid personally. That is not a fairy tale ending for anyone. It is how law works. Paper defeats noise. I moved my father's old toolbox to my storage unit. I found little things that made grief rise in my throat and blow out quietly. A stub of a pencil with bite marks, a folded receipt from 2007 for a water heater he installed for a neighbor at a discount, a note that said, "Call Aaron," pinned under a magnet shaped like a wrench. I kept the note. I threw away the pencil. You can't keep everything. That is true of objects and also of anger. I also made a plan for the house. The toady had transferred it to me, subject to the mortgage. I met with the bank in early August and refinanced to remove my father's name and drop the interest rate. The numbers made sense. Loan balance $161,300, rate 5. 25. Monthly principal and interest $892. 94. Rent upstairs covered everything and left a buffer for repairs. I scheduled a plumber to install a new shutoff valve because everything eventually leaks. I labeled the key for the basement. I took a photo of the furnace label to file under model numbers. Thinking clearly about small things keeps big things from knocking you down. There were obstacles I haven't mentioned because they were boring in the way most real obstacles are. A misfiled affidavit that needed a new signature. A court date that got bumped because the judge had a bench trial that ran long. A notary who used the wrong stamp at first and had to re-notarize in front of a supervisor. A clerk who told us to check back next week because their case management system was down for an update on June 14th. We navigated each one the same way. Patient, documented, relentless. As for the codicil, I made a choice not to take it apart for sport. We could have challenged it with hospital logs and a notary journal, inconsistency, and a handwriting expert. We didn't need to. The law gave us a cleaner path. I don't know if the codicil was my father's free act. I suspect not. I will never know for sure. Don't know is a complete sentence that sits heavy and true. I don't need to fill it with glitter or rage. The biggest twist wasn't in court. It was in a conference room at the bank when the manager who handled the TOD transfer processed the final step and said, conversationally, "It's rare, but we do see agents try to use POAs to change beneficiaries. We don't always catch it." He looked at me like he expected me to be angrier than I was. I said, "That's why I record things." He nodded. He didn't ask about the channel. If you're listening to this, because you're in the middle of something like it, a will that cut you out, a relative who thinks volume equals victory, a bank that speaks in procedure, 2 pieces of advice from someone who just came through it and still has the court notices on her fridge. First, separate probate assets from non-probate assets. Wills don't reach everything. Transfer on death designations and instruments work if they're done right and recorded where they need to be. Second, look for the clause nobody reads. Powers of attorney are powerful. They are also fenced. If a clause says, express authority required, it means exactly that. We thought it was fine is not authority. There's a temptation to make this a story about good and evil. It isn't. It's about incentives and paperwork, and where people put their fear. Diane was afraid of being left without control. Tyler was afraid of not getting a payday. I was afraid of being erased by people who use the words, we decided, like a weapon. Fear makes people sloppy. Calm makes you read. Reading closely won me my house and my share and my dignity. At the end of the settlement conference, when the mediator left to draft the last page, Diane turned to me and said, he loved you. I said, he loved you too. Both statements were true and didn't cancel each other out. That is how families actually are. Messy and layered and unfair and sometimes fixable with rules that were written by people who knew families would be like this. I haven't gone back to the funeral home since the day we chose the urn. I did go to my father's favorite diner on Western on August 10th and ordered his usual black coffee and a Denver omelet with extra onions. The waitress recognized me and said, how's your dad? I said, he passed in March. She put her hand on the table, just 2 fingers, a small gesture. He always tipped in cash, she said, smiling. I left a 20 and walked out into humidity that almost broke into rain. I stood there for a minute and let it not rain. Sometimes people ask if I'll ever talk to Diane again. I don't know. Right now, we communicate through lawyers when needed and through silence when not. That's healthier than pretending. Tyler sent me exactly 1 text after the buyout signed. We'll make the payments. I replied, good. The payments hit on August 1st as scheduled. If they miss one, the default clause is there like a seatbelt I hope I never need. If I could rewrite the past, there are conversations I'd force us all to have 2 years earlier. I'd make my father meet with me and a neutral attorney in 2022 to walk through everything with all of us in the room. The will, the trust, the DPOA, the TODs, the buy-sell. I'd make us sign an acknowledgement that we understood who gets what and why. I can't make any of that happen now. I can only make a video that someone else might stumble on at midnight when they can't sleep because they've been told they don't matter on paper. You matter. The paper might agree with you if you find the right page. I named this channel after her lies because it started with a breakup and a credit card bill I didn't know I had. It's grown into something else. It's where I put the part of me that doesn't want to be talked over anymore. If you see yourself in this story, it doesn't make you a villain or a victim. It makes you someone standing in a room with fluorescent lights and a stack of forms, trying to make sense of sentences that change lives. You can learn them. You can use them. You can refuse to be erased. And if you're here at the end, here's the clean truth I promised at the start. They plan to sell the business without me. They plan to empty a brokerage account by changing a beneficiary with a magic signature. They plan to treat a recorded instrument like a suggestion. The will reading felt like a performance of my disappearance. 2 orders, 1 clause, and 3 signatures later, the judge made the bank transfer the $330,000 to me, confirmed the house in my name, and restrained any sale of the company without my consent. Then we used those facts to settle the rest. It wasn't a twist so much as gravity doing its job. Paper doesn't care about volume. If this helped you, I need a favor to keep teaching this without noise. 96% of viewers aren't subscribed. Hit subscribe like this and tell me in the comments what clause you want me to break down next.